Welcome to Antitrust Code by Concurrences. Concurrences is the leading antitrust database with over 30,000 articles on competition law. Concurrences is also the largest network of antitrust experts, with lawyers, economists, enforcers, and academics in 85 countries. By listening to this podcast, you will learn the fundamentals of competition law and hear about the latest antitrust news, thanks to our guests, the best experts in the antitrust world.
Welcome to a new edition of Antitrust Code. This one is focused on joint ventures in the Americas. My name is Neil Campbell. I'm a partner at Macmillan in Toronto, and I'm one of the co-editors of the book Competition Law Treatment of Joint Ventures, which we are highlighting in our discussion today. The book was written by members of the Mergers Working Group in the IBA Antitrust section, and it's been published by Concurrence. This is the second Antitrust Code podcast that we have leveraged from the book. I hope that some of you enjoyed the first podcast that was hosted by my colleague Alistair Mordaunt, one of the other co-editors, a few weeks ago. Today, we're going to speak with two of the major contributors in the Americas. And from the U.S., it's a pleasure to be chatting with Sonia Pfaffenroth, an antitrust partner at Arnold & Porter in Washington, D.C. And from Brazil, it's an equal pleasure to be chatting with Renata Zuccolo from the Matos Filho firm, a partner in their competition group in Sao Paulo. Let's get started. Sonia, I think you drew the first straw. Joint ventures in the antitrust context. The concept of joint ventures is a bit loose, a bit free-flowing. People talk about different attributes, whether they be full function or not, whether they be concentrative, cooperative. In the U.S., how do we know if we have a joint venture that is going to be treated as a merger in the U.S. system?
So the DOJ and the FTC have very long-standing guidelines that are called the antitrust guidelines for collaborations among competitors. And those guidelines primarily provide guidance with respect to collaborations, including JVs that do not constitute a merger acquisition, that would not be analyzed under the merger laws. And while the guidelines explain the differentiation as that the agencies typically will treat a competitor collaboration as a horizontal merger and analyze it under the merger laws if they give criteria. So if the JV participants are competitors in a relevant market, if the formation of the JV involves or the collaboration involves an efficiency enhancing integration in that market, if the integration eliminates the competition between the participants in that relevant market, and the collaboration does not terminate within a sufficiently limited period by its own terms, which the guidelines note depend on the circumstances, but sort of put a 10-year rule of thumb on that. So in the US, JVs that are analyzed are mergers may be subject to notification under our pre-merger notification requirements under the Hart-Scott-Rodino Act if certain jurisdictional thresholds are met and there are not applicable exemptions. You mentioned full functionality. The concept of full functionality is not determinative under the HSR Act. So if the criteria are met, then the JV is notifiable, regardless of whether it's full function or non-full function. And typically, in terms of assessing the impact of a JV under the merger standards, as with non-JV transactions, the agencies are looking at market concentration, unilateral effects, coordinated effects, entry, and inefficiencies. Something that's important to note under the U.S. Regime, though, is that both the FTC and the DOJ, they have authority to investigate, for example, a JV that would be characterized as a merger, even if it's not notifiable under the HSR Act. They can investigate both non-reportable transactions and transactions that have already been consummated.
So it sounds like a fair number of joint ventures might have the attributes that would get them treated as mergers in the U.S., but some will not. And what's the legal position or framework for a joint venturer that is not joint venture merger in the U.S.?
So I would say both in the context of a JV that would not be analyzed as a merger, but also with respect to a JV that's notifiable and cleared by the authorities, it doesn't provide the parties with protection from future intervention by the enforcement authorities under the antitrust laws, under the Sherman Act, potentially subsequently under the Clayton Act. So, for example, if there's a situation where the JV parents compete, clearance would not insulate them from liability under the Sherman Act with respect to information sharing, sharing of competitively sensitive information, or an agreement between a JV and a parent that competes with the JV would also still be subject to analysis under the Sherman Act, unless, for example, the parent controls the JV. So if they have more than 50% ownership, then that would be a different consideration. And typically, if you're looking at analysis under the Sherman Act, then if you've got a restrictive agreement that's ancillary to a legitimate JV, then that restriction, like a non-compete, for example, that's going to be analyzed under the rule of reason under U.S. law. So the legality of the restriction would depend on the anti-competitive effect or pro-competitive effects associated with it.
Okay, thank you for that sort of scene setting. Renata, I'd like to do the same on Brazil and sort of understand, at least at a high level, to what extent we may have some similarity and difference. So starting with in Brazil, what kinds of joint ventures get treated and analyzed as mergers?
Thank you, Neil, and it's a pleasure to be here with you and Sonia. So in Brazil, we do have a specific provision in the law stating that joint ventures are a type of act of concentration. So this is written in the law. So to the extent that any joint venture meets an effect stat, meaning that it has at least a potential effect in the Brazilian market, and the parents to the joint venture meet the revenues threshold, it will be considered a merger and subject to mandatory filing. And since our revenues thresholds, for those who are familiar with the Brazilian thresholds, they're low in comparison with other jurisdictions, I would say that a great number of joint ventures are captured by this rule. So it's very common to have in Brazil joint ventures being reported as mergers and subject to this clearance by antitrust authorities. That's being said, I heard Sonia saying, and we also have a provision in the Brazilian law that allows the Brazilian authorities to request a mandatory filing, even if the revenues thresholds are not met. Maybe the difference here in relation to the US is that the Brazilian authorities do have a deadline for such requests, and the deadline is 1 year from closing or from the implementation of the joint venture. So if we pass this time lapse and you do not have the obligation or a requirement to file, the joint venture would not be seen as a per se illegal. But if you do have any kind of harm to the market, there will still be the possibility that this joint venture can be investigated under pure investigation to see whether there is any infringement to the Brazilian competition law. And we have searched, I have never seen a precedent of this specific situation of a joint venture being investigated by Brazilian authorities, but again, it's possible.
Okay, thank you for that overview. It does seem that you are merger focused, but it's interesting to look at these transactions and a little bit more as merger transactions. And Sonia, I'll come back to you. And you mentioned a little bit about the possibility that you get a reportable merger in your Hart-Scott-Rodino Act notification regime. Been a fair bit of news about changes in that regime of late, and maybe you could just discuss briefly what the implications there might be for people who are looking at joint ventures that may be reportable mergers in the U.S.?
Yes. So last summer, the Federal Trade Commission announced proposed rules that would significantly expand the information that's required to be provided with the initial pre-merger notification in the U.S. The notice of proposed rulemaking is over 100 pages long. So it has a lot of detail about potential additional information that the agencies would require, potentially more relevant with respect to JVs or companies that are looking to participate in transactions that also participate in JVs. The requirements include expanded requirements to provide information regarding minority holders, other types of interest holders, expanded reporting requirements with respect to both the controlled entity, minority held entity overlaps, and just more generally for notifiable transactions, the revised rules, if they're adopted, would require information regarding officers and directors, information about other boards on which they sit, narrative descriptions of horizontal overlaps, of supply relationships, of labor markets, expanded information about prior acquisitions from both filers going back 10 years, eliminating the current $10 million thresholds, information about subsidies, respect to certain foreign entities or governments, information about categories of employees, OSHA violations. It's quite significantly expanded. And so the estimation from the FTC is that currently the average filing takes 37 hours, and under the revised rules, it would take 144 hours for a company to complete the requirements. I think our view is that for many transactions may significantly underestimate the time that's actually required.
So in particular, your comments about minority interests and some of those interrelationships sound like they will have implications for parties involved in joint ventures over and above some of the other general points you talked about. I think, let me go back now to Renata and get in a little deeper in terms of cases, because I think you've had a couple of interesting cases dealt with as merger joint ventures in the regime in Brazil, in particular, I think involving some environmental sustainability issues. And I think those would be interesting to talk about it if you can give us a little bit of an overview of some of the learning from these recent cases.
Yeah, sure. We had two very interesting recent cases. And as you mentioned, they both were related to environmental initiatives by competitors or by companies within a given industry. So the first one was a case which we'll call Catena X. This was a joint venture, and the parents' companies, so the shareholders to the joint ventures, were companies within the automotive industry, such as BMW, Volkswagen. You did have other auto parts entities such as ZF and others. And they got together and they formed this joint venture. And the purpose of the joint venture was to exchange information and to have some kind of technical cooperation in order to implement ESG initiatives, which are very important for a lot of industries. But in the automotive industry, I think this has a special concern. So those companies, they formed the joint venture. This was reportable in Brazil as a merger. The merger was reviewed by our general superintendents, which is the first level of review. The review was very much focused on two aspects. So the first one was whether there would be any market share increase. And the answer to that was no, because there was no concentration among the core activities. So this was a pure collaboration joint venture. And the second concern, which was reviewed by the general superintendents, was whether this technical cooperation could create any kind of standards that could be used in a discriminatory way. And the answer was also no. So the case was cleared by the general superintendents, but as some of you may know, we have in Brazil the possibility of one of the commissioners at the tribunal level to request a second review of the case. And this happened and in this situation. So the merger case was sent to the tribunal. And during the review at the tribunal level, a lot of concerns on the information exchange were raised. There was a lot of discussions on what kind of measures the parent companies could adopt in this case. There was even, based on the public records, apparently there was some negotiation between the parties and the tribunal, but in the end, there was not a consensus on what kind of measures could be adopted to avoid such a high level of exchange of information, according to the Brazilian authorities. And in the end, the deal, which was a global dispute, it was blocked in Brazil. So this was a case, it was ruled December last year. And then on June this year, we had a similar situation, different industry. So some commodities companies such as Cargill, Louis Dreyfus, and others, they decided to incorporate a joint venture, which had the aim of building and providing a software service for all the supply chain in the food and agriculture industry to track the supply chain and have some kind of standards on the measures regarding sustainability. So this was the aim of the joint venture. As in the previous case, this was sent to the general superintendents. The general superintendents raised some questions about whether those standards could be discriminatory or not. The answer was no, and the transaction was cleared by the general superintendents. But then another commissioner asked for a second review of the case. And as happened before, the case was sent to the tribunal. And once it reached the tribunal, according to the public version of the decision, the parties to the joint venture provided a very robust and complete antitrust protocol to deal with the information exchange for the JV, so within the JV and between the parties to the JV. And they also provide the governance rules of the JV that will show that no discrimination will be put in place in relation to the parties to the JV and to third parties who could hire the service provided by the JV. And in the end, the tribunal decided to clear the transaction, not subject to remedies, but based on the assumption that the antitrust protocol and the governance rules would be put in place. So we kind of see some kind of upfront behavioral remedies being presented and to the Brazilian authorities, which allow the case to be clear without any remedies. So this were the both cases recent regarding this topic.
Thank you. It's fascinating to see two similar cases and the different results, and very interesting to see the focus on the information sharing issues. And I wonder, Sonia, if I can come back to you and talk about the issue of information sharing, which I think is a lively issue as well in the U.S. right now, and what joint ventures need to know about that in the U.S.
Yeah, and it's quite interesting to hear Renata's case descriptions. It is a lively topic in the U.S. right now. Not specific to, or not limited to, I would say, to JVs, but earlier this year, the Department of Justice withdrew its support for these. It was a set of policy statements from the 1990s that specifically related to healthcare markets, but they included certain safety zones regarding information sharing that had been relied on for quite some time across industries, not limited to healthcare. And in withdrawing those statements, the DOJ, focused on the information sharing and specifically characterizing them as overly permissive on subjects like information sharing. So previously, the safety zones that had been articulated there regarding, for example, industry exchanges of information would not be challenged, absent extraordinary circumstances if they were managed in a certain way, managed by a third party, making sure that data was stale, that it was aggregated, anonymized to prevent linking to a specific source. And part of the articulation by the government of the concerns with the existing safety zones was that the proliferation of data and the potential to use AI and data analysis to disaggregate what might otherwise be anonymized and aggregated data was one of the things that they pointed to in calling into question the continuing viability of the previously articulated policies. And so, the government's view that was articulated was that this is, in modern markets, it's a case-by-case approach. And so I think, from a practical compliance perspective, the withdrawal of that guidance without its replacement by superseding guidance has introduced, uncertainty as to where the government's focus might be with respect to future enforcement, with respect to information sharing in any context.
Thank you. Interesting times for sure. Renat, I think you have one other recent case that's interesting in terms of behavioral remedies. If there's a chance to hear briefly about the implications of that, that would also be very interesting, since there's been a lot of activity at CADE.
Yeah, thank you, Neil. There were other cases, but let me, I'm cautious about time, so let me talk about a case that we call the Simba case. So this was a joint venture that was filed for clearance back in 2016. It was a joint venture formed by Brazilian channels, so TV channels and content producers, that built this joint venture to provide services for the media sector in an attempt to decrease costs of those services. And back in 2016, this was a very complex merger. It ended up with some behavioral remedies. And one of the remedies was that the JV could last for 6 years. So what happened is that then the parties have to file again and ask for an extension of the joint venture. And this time they asked for a 14 years extension. And during this new review, CADE decided to look at the market before the first clearance, between the first clearance and the second request for the extension, and they, so the Brazilian authorities realized there was not a lot of concerns on a lot of things that in the previous clearance was indicated as a possible concern, but they were still concerned about the fact that you have a lot of competitors and big, what we call operators, getting together to form a JV that will provide related services to those companies. So the behavioral remedies here, which were now negotiated and agreed with the Brazilian authorities, was that the JV could last for another 14 years, but they would have the obligation to negotiate with third parties. So the JV cannot only negotiate with its shareholders, and they have to give the same commercial conditions to small and medium-sized operators, which was a way to avoid not only discrimination, but foreclosure effects on this. And there is also a provision that the JV cannot charge higher prices to the third parties than they charge to its shareholders. So again, another interesting case regarding joint ventures and among competitors.
Thanks, Renata. I think that we are at time for this edition of the Antitrust Code. I want to thank you, Renata and Sonia, both for having a chat with me today and for sharing your insights into some of the complexities and some of the recent developments in both your jurisdictions affecting how joint ventures are handled. For listeners, I hope you found this discussion interesting, and if you have, the book is Competition Law Treatment of Joint Ventures. It's a full-on guide to the competition law treatment of both merger and non-merger aspects of joint ventures in 22 jurisdictions around the world, and it's available from Concurrence. With that, let me wish you a good day, and hope you will join the next edition of the Antitrust Code. Thank you.
You listened to an episode of Antitrust Code by Concurrences. If you want to read more about this topic, check the Concurrences website, where you can find all relevant articles. Follow us on Twitter @CompetitionLaws, and join the Concurrences group on LinkedIn to receive updates on our next podcast.